Chancellor, Bharatiya Vidyapeeth, Honorable Dr. Manikrao Sarunkhe, Sir, Professor and Vice Chancellor, Bharatiya Vidyapeeth, and Honorable Dr. Vishwajit Kadam Sahib, Secretary, Pro Vice Chancellor, Bharatiya Vidyapeeth, under their able leadership and under the guidance of our dynamic Dean and Principal in charge, Dr. Ujjwala Bendare, Madam, we are able to constitute this AETIP cell, in which our basic aim is to promote and create more researches and things like that in intellectual property rights and cyber laws. So I welcome one and all for this session. I request Rohit Kulkarni, our student core of AETIP cell, to take over and welcome the guest. Thank you.
Thank you, Madam. Good morning and welcome once again to everyone and our honorable guest to the second day of the Faculty Development Program on IPR. So we had a very exciting and interesting first day where Professor Advocate Ganesh Hingmere sir covered a lot of details and very interesting information about geographical indications. And as I remember him mentioning, he called geographical indications, or the products which can be included under that, as patents of our forefathers. And then we went on to discuss or learn from Advocate Tanu Singh ma'am about patents and patent cooperation treaty. So today we are now here with our first guest of the day, Advocate Ashish Sonawane sir, and he will be enlightening us about traditional knowledge and confidential information. So I guess it's taking the topic from yesterday about geographical indications, the patents of our forefathers, and I suppose Sonawane sir will now go more in depth about this and what traditional knowledge is and how this can be covered under intellectual property. So thank you very much, sir, for making your taking valuable time to address our gathering. I now hand over to my colleague, Ms. Aditi Srivastava. She will introduce sir, and then we can begin. Just one request to all the participants, if you could please mute yourselves before we begin. In case you have a question, you could raise your hands and we will unmute you when you could ask a question. Or you may, if you prefer, share the question with us. And my colleague Aditi or Raj Lakshmi ma'am would be happy to take them up on your behalf. Aditi, you may continue.
Good morning, everyone. I welcome you again on the second day of Faculty Development Program on Intellectual Property Rights. I'm extremely overwhelmed to get this opportunity to welcome our guest on behalf of Bharatiya Vidyapeeth Law College. I would like to introduce Advocate Ashish Sonawane sir. Sir is a technology lawyer with 16 years of experience. He worked as a software engineer, business analyst, and delivery manager for banking and financial services industry. He is the founder of Nyaya Niti Prabodhini. He is registered patent agent and specialization in domain of electronic and information technology. He is also a registered member of Silicon Valley Arbitration and Mediation Center and an accredited mediator of Indian Institute of Arbitration and Mediation Center. Sir will be taking session of traditional knowledge and confidential information. So I request you to please proceed with your session.
Thank you for the warm words and warm welcome. I'm sharing my screen for my presentation. Just a second. I'm getting options here to share the screen. Is my screen visible to?
Yes.
Yes, sir.
Wonderful. Yes. So, as very rightly pointed out by Rohit in the beginning, that yesterday my senior colleague Ganesh Hingmere ji has introduced you to GI, and he must have touched upon some of the aspects of the traditional knowledge or the knowledge of forefathers. So that's a very good foundation, I would say, to begin with. And like Tanu has also spoken about the patent aspects, because traditional knowledge is actually an encompassing term which actually cut across horizontally to all the verticals of the intellectual property rights, as we know. So I would be covering all those aspects in this session. I'll be, if you have any questions, just put it in the chat box. We can actually take all the questions in the end. And
Sir, actually, we have connected to the YouTube. So
oh, is it?
the chat box, yes, the chat box will be disabled.
Okay.
They will put up their questions to me, sir. I would go ahead,
Not
or
an
one
issue.
of the students. Yes.
Yep, not an issue, not an issue. So the questions can be taken in the end. So now we shall proceed. First of all, we need to understand what the traditional knowledge is. So I have put up the definition of the traditional knowledge as such. However, being Indians, do we really need to define traditional knowledge? Because since the very young age, we are actually exposed to the traditional knowledge from all the factors, right? The way we do prayers, the way we eat, the way we drink, the way we speak. In fact, in every aspect of our life, we have one or the other element of traditional knowledge playing a big role. Whether we are tribal or not is a secondary question, because every Indian is the flag bearer of the culture, the tradition which we are blessed with. So traditional knowledge is something which is in our bloods. However, for the sake of definition, if at all we need to define per se the traditional knowledge, then I would say, in fact, this is a definition which is from the WIPO, that the traditional knowledge is know-how, skills, and practices that are developed, sustained, and passed on from generation to generation within a community, often forming part of its cultural and spiritual identity. So what are this identity if we talk about knowledge? Yeah, putting turmeric in our milk, right? When we are coughing or when we have some sort of temperature. Is that a knowledge or is that a know-how? How to put that turmeric, is that a skill? Putting that turmeric each time when we are sick, is that a practice? Was it not developed over the years? Was it not sustained and was it not passed on from generation to generation? So very simple example of turmeric, which can be termed in medicinal herbs, which we are using. That is what is the traditional knowledge. Similarly, handlooms, right? Yesterday, Ingmere sir must have told you about Paithani saris, which is something, a tradition of saris in Maharashtra, which is known, which has now been GI'd. So handlooms, we have traditional knowledge. And not only Paithani, we have similar silk products available across the country. If we go to Kerala, then Nalli silk is one such example. If we go to Banarasi silk is an example. So every part of the country has one or the other type of handlooms, which we are actually using from generations to generations, from hundreds and thousands of years. We're using all these things. So handlooms is one such example of our traditional knowledge. Architecture, right? So we have all these temples, beautiful temples which are created. We either it can be of Hemadapanthi Shaili or any other Shaili or type which we talk about. Our architecture is an example of our traditional knowledge. Folk arts, Warli paintings. I'm sure you all must have seen the expression of Warli paintings. What are those? Those are nothing but our traditional knowledge. Similarly, dances. Oftentimes, we see the tribal dances, in our movies. What are they? They are nothing but a traditional knowledge. Even our Kathakali, several of them are very popular. What are they? They all are traditional forms. Music, tribal music, the folklores. These all are types of traditional knowledges. Similarly, jewelry designs, in every part of the country, we have distinct jewelries. I remember some time ago, while some excavation was going on at Raigad, some jewelry items were found of that era. So that specific designing of jewelries are traditional knowledge. Scientific and technological expertise. When we talk about certain texts, in terms of Vedas, in terms of Ayurvedas, or in terms of Dhanurvedas, wherein a lot of scientific experiments are given. So that is an expression of the scientific and technological development which we had back in that time. Similarly, literary work, if we talk about Ramayana and Mahabharata, the great epics which are known, which is a work of history for this country. Similarly, we have had various laureates, I mean to say, right from Banabhatta to Kalidasa, wherein all these people have put forth a very distinct literary style, literary works they have developed. That is also our traditional knowledge. The way we preserve our ecology, the way we live in harmony with the nature is also our traditional knowledge. Now, even the agricultural processes and methods. So we are one of the most ancient, because Chinese are also claim that they are also ancient. So we can say that okay, we are among the ancient civilization. So how did we sustain? We call ourselves as an agricultural economy, agrarian country. Similarly, we have the agricultural processes and methods which are developed for a very, very long time. So this is all encompasses the definition of traditional knowledge. हम हिंदी में कहते हैं कि भारत की धरोहर. So that dharohar, that Sanskritic varasa which we actually carry forward, is all example of the traditional knowledge. So what are the key elements of traditional knowledge? This is a beautiful image that summarizes, the key features of the traditional knowledge. It passes on from a generation to the other. It can be a particular tradition restricted to an individual family or a community. Most of the time, these are the community rights, and these are evolutionary in nature. They evolve with time. It's a classical feature of our tradition that we don't really stuck to where we were. We continuously evolve. So all our traditional knowledges, traditional, they have a common feature that they are evolutionary. They evolve over the period of time. If we talk about the numbers, sometimes these numbers make a lot of sense, because traditional knowledge, whenever the subject has been referred, it has been primarily thought in the context of the historical knowledge, and we are often blamed that we live in history and we don't live in present. However, these numbers would shed a very an eye-opening kind of facts and figures before you. So if we think about the primary healthcare, TK caters to 80% of the population. The traditional knowledge, it is their primary health option. So this modern Western medicine, which we talk about, have not reached to the not even the half of the population. It is just 20% if we talk about that number. Then how many people we're talking about when we consider the traditional knowledge as such? The figure goes to 370 million, which is a huge number. If we consider the entire lot of Indian population, which is a huge chunk of it, we all are indigenous. We are India, right? So we are old. We are traditional. We have the heritage. So not only the tribals, but all Indians. Even though we are living in big cities now, but we still, the grandma's turmeric latte. The way I'm, the way it has been called now by the Starbucks, that turmeric latte. The turmeric latte has been given to us since our childhood. So 370 million population, which is something which falls under this landscape. Now, it is one of the most important factor for the maintenance of ecology and environment. Now we're talking about global warming. We're talking about, in fact, we're seeing the effects of the global warming with the, with the way the nature is behaving. We just had massive floods in Maharashtra last week. It's an example of the change in the ecology and change in the environmental conditions which we are living. Now, when we consider the original life, I mean to say the indigenous life, that life is always in harmony with the nature. Therefore, the persons who are the holders of the traditional knowledge, or who holds the traditional knowledge, are the persons who are responsible for the maintenance of the ecology and environment. That is why it is very, very important. Now, since I was talking about environment, biodiversity plays a very important role. 90% of the different forms of biological forms which are available on Earth are from the countries like India, Mexico, Brazil, Indonesia, Australia, and Congo. The names of the countries are visible, and if you see the sizes of these countries, we do cover even a large portion of the Earth's geography as well. Now, if we talk about India-specific facts, 583 plant species are cultivated in India. 334 wild relatives of the crops are available in India. We are 10th among world and 4th in Asia so far as the plant richness is concerned. We are 7th in plant diversity and we have 7% of mangroves of the world. And if we consider the medicinal products, 95% of the medicinal products are based on the plant varieties. Therefore, this plant, tribal population, biodiversity, ecology, environment, they all are connected with each other. And that's why we cannot look at them in isolation. Now, what has happened? So whenever we see numbers, and as I understand, we have gathering of the eminent lecturers and professors from all faculties. So there's a basic principle that wherever there is number, there is a market, right? So if we have such a massive, impressive numbers with us, wherein we can produce globally consumable products, what happens? A competition starts, and this competition is not about ordinary product. This competition is about, in a way, very essential products for the existence of life. So, a growth in the organic research has happened. Now, this growth in the organic research is not bad all the times, because when we talk about ecology and when we talk about organic living or healthy living, we need that invention to happen. However, that invention should happen in tandem with the nature while protecting the traditional knowledge. That is what the claim we are making here, so far as the research is concerned. I'll be showing a small video to you all, and I want you to have a look at it in a very precise video. The entire gist of the subject has been covered in this video. This video has been uploaded on the WIPO's YouTube channel. So I have taken it from them, courtesy to them. So please have a look at this video.
Tucked away in a tropical rainforest, among the tallest trees and the smallest frogs, lives the Yakuanoi people. Like many indigenous peoples, they've developed their own unique set of skills, practices, and innovations. Carefully passed down from generation to generation, this traditional knowledge forms an invaluable part of their identity, as well as an economic and cultural asset for their entire community. One Yakuanoi innovation is particularly celebrated. Once a year in late spring, the Yakuanoi come together to begin carefully harvesting the rare Surian's shoot. The vibrant green shoots are carefully separated from the leaves and roots and placed in large clay pots. Under constant care, the mixture transforms into an oily brown paste, and the Yakuanoi have a new batch of their skin marvel that can be used to heal burns or skin conditions like eczema, or even be used as an effective moisturizer, keeping skin looking youthful. Highly prized for its healing properties, the paste has always been bartered and traded in neighboring villages, and so for many years the Surian paste has formed the basis of the Yakuanoi community's economic livelihood. Word of the must-have Yakuanoi's paste traveled beyond the community. Always on the search of new and innovative resources, a cosmetics company researched the active ingredients of the Surian shoots. Impressed with its antibacterial benefits, they began to mass-produce an anti-aging face cream for distribution worldwide. Excited by its potential, the company quickly applied for a patent to protect its product and also registered a trademark using the name Yakuanoi. I had no idea that the traditional knowledge of my Yakuanoi people and the Surian shoot would have so much potential. Now in the city I call home, I couldn't help but notice advertisements everywhere for this new miracle face cream. Having left my community years ago to study law, I couldn't help but wonder, what does intellectual property have to do with traditional knowledge? Can and should intellectual property law protect it? The company has made an investment in their products, so what would be fair in a case like this? In search of a trusted source of information, my first step led me to the World Intellectual Property Organization. It wasn't long before it became clear to me that the intellectual property system can be used strategically to protect and promote traditional knowledge. Patents can be revoked if inventions are not new. Trademarks can be challenged if they confuse people. But it was also clear that there are limits to the existing intellectual property system that fortunately countries at WIPO are working on. WIPO introduced me to the local intellectual property office in my country, which was also very informative. It was time for me to visit my village and collectively decide our approach. I organized a meeting and we agreed to talk with the cosmetics company. We expressed our concerns that their anti-aging cream used our traditional knowledge. We also explained how their trademark was given the impression that the cream was an authentic Yakuanoi product, benefiting my community. This was not the case. After a series of productive discussions, the company agreed to resubmit their patent and trademark applications with the Yakuanoi as co-owners. This meant that profits and employment opportunities would be shared. While these issues are difficult and community experiences vary, I could return home proud of my community's traditional knowledge and with a new awareness of the need to make smart use of intellectual property rights. The more our communities know about intellectual property, the better our position to protect and promote our unique cultures.
So this video, a 5-minute video, actually summarizes the entire topic which I'm covering today. So traditional knowledge and its commercial value is something which has been discussed. And in this clip, we had a very positive and happy ending wherein the company agreed with the traditional people, the knowledge bearers, for profit sharing, revenue sharing, and in fact sharing all the aspects. But in the real world, oftentimes, the end is not that sweet. In fact, we are land of Bollywood. We are land of drama. So in real life, what we actually see is something like this: biopiracy. What happens in the case of biopiracy is that the big giants, big corporates, or sometimes even the small players, they want to ripe on the benefit of the community because they have different disadvantages for these communities. When we talk about some specific things, even if our community, I mean to say India as a whole, when we talk about the awareness, and gladly I'm speaking at one of the prestigious law schools in the country, the status of legal aid or the status of legal awareness is very minimal, even in big cities. Think about it in the villages, think about it in the tribal areas. I happen to be one of the directors of a think tank called TIR, which specializes in the research in the tribal people, livelihood of the tribals. The scenario in the tribal lands, in the tribal areas, is very difficult. I mean to say, their rights. We oftentimes talk about various rights, freedom of expression, all these things. But when we go to these places which are tribal, they don't even have basic awareness and understanding about their statutory rights, forget about the constitutional rights out there. So it's a very happening and very conducive breeding ground for the biopirates to come in and steal our resources. So the exact case, because in the video as well, what we've seen is that it is something similar to our turmeric case, right? The magic potion or the magic ingredient which the tribal community had, which was exploited in a way by a company. And since they retain their name and everything else, so they must be aware that, okay, there is a community which exists, and whatever profiteering they're earning, a portion shall go to the community as well, and informed consent must have taken from them. But it was not done unless and until somebody shouted. So that is something which is very essential and crucial. So why this biopiracy comes in, and what are the effects of it? These biopirates typically, they steal our traditional knowledge, they patent it, and they sell it as their own product. They apply for unfair patents, as I said. It is primarily either based on theft or assumption. It is also resulted in terms of the depletion of the biodiversity and wildlife. Why I'm stating so? Because all these products, in a way, forest products, or the products which are developed or which are result of the indigenous population, they are also source of income for them. For example, in India, when we talk about basmati rice, or when we talk about Assam tea, or when we talk about haldi for that matter, the turmeric, these all are very important players in our economic activities. So if we are being restrained because of the unfair patents by somebody else, doesn't it reflect in terms of our livelihood? And if our livelihood is impacted, doesn't it impact on our biodiversity and the existence of the wildlife? Indeed, it will. Therefore, the effects are chilling of this biopiracy. In a way, it is not only stealing of our traditional knowledge, but it is also stealing of our economic well-being, our opportunities to earn from our own traditional knowledge, from our own source. That's why this picture, in a way, summarizes how these biopirates typically, steal from the indigenous people. Our forest products, or our agricultural products are patented by somebody else, and we are being made slave. So that is something which is very, very crucial and important thing to understand. Some of the cases I would be now covering. So Neem Patent is actually one of the early cases, wherein the patent for the neem seeds and its key feature of fungicidal, that it doesn't attract the fungi or even the pesticide as well. So these days, while we have very heavy focus on the organic methods of farming, wherein we have certain techniques like Subhash Palekar's technique is now coming in, and wherein he is actually promoting all these neem-based, repellents, fungicides, pesticides to be used instead of the chemical alternatives. So similar thing was done. So what was done is that it was used as neem was used as the inventive and novel step. Now you would have covered the patent aspects yesterday. So what a patent is required to get a success in terms of registration, that it should be novel, it should have an inventive step in it. So for in the case of neem and its use as a fungicide, is there any novelty in it? No, because we are using it since generations. There's nothing new in it. And not only we, I mean to say the entire country per se has been using these products. In fact, neem ka toothpaste, I mean to say even the neem sticks are used for our mouthwash purposes, for teething purposes. So we opposed, and the patent was finally revoked. Same goes with haldi. It's a very famous case. 1993, the University of Mississippi, filed a patent application which was registered. And it was very similar to the video which we saw a while ago. For the healing capacities of the turmeric, it was registered. We objected, again on the ground of novelty. Novelty is an essential ingredient for a patent. Patent cannot be granted. And our qualities and our references, our use and citations from the ancient text, we got it removed. That's about Haldi. Basmati patent. Now, Rice Tech is a US company. It obtained a US patent on the type of rice. It's basically a strain of Indian basmati rice. They actually produced a hybrid variety, and they filed a patent. Now, you all know that a patent, in addition to novelty and inventive step, must cite the claims of the patent. Now, what are the claims which are cited by this Rice Tech? They say that all the rights for the rice grown in the Western Hemisphere, basmati-like rice, would be under their patentable right. They also sought the rights for the future variants produced by crossbreeding of new varieties, with the existing Asian varieties. Imagine the impact. Imagine how these companies would have, fought with us for the basmati rights. And I have just put a number. This is again an old number, that the basmati economy, the export valuation, is $800 million a year. So imagine the economic impact of the traditional knowledge. That's about basmati. Then yoga. So we call yoga as the world heritage. Yoga is not limited to any particular community, any particular region. However, there is no denying that yoga is of Indian origin, our origin. So if it is of our origin, at least a credit should be given for the originator country. However, if we see even some of our people, some of the Indians who are staying in the US, who are NRIs, some of them have applied to get copyright. So Bikram Chaudhary's example I have cited here. He has filed an application to get copyright for his method of teaching of yoga, and he also applied for patent. Now, again, these are some of the old data points wherein USPTO had issued 150 yoga-related copyrights, 134 trademarks for yoga accessories, and 2,000 plus yoga trademarks. Now, the question is, if the yoga is world heritage, can such a commercialization for some individuals or some individual entities, companies be allowed? There's a very strong view, strong objection has been taken by India. The proceedings are on, the battle is heavy. However, the battle is required to be fought. And therefore, some of these things could be legitimate. However, a larger question about utilization of the traditional knowledge is there. Now, wheat patent, naphal. So naphal is one of the Indian variety wherein Monsanto has obtained a patent. It's an European patent, and it was objected once again. Major role was played by Research Foundation for Science and Technology and Ecology, along with Greenpeace and Bharat Krishak Samaj. The battle was won and the patent was removed. So these are some of the examples from India. Now, if you talk about another example outside India, then ayahuasca is an example from Amazon, wherein a wine of native Amazon rainforest. Again, it has similar qualities, healing qualities like that of turmeric. It was used for ages, generations, by the healers and religious leaders for treatment of sickness, spirit contacts, the way we call it. Since we are ancient civilization, we have certain other elements anyways, but these things have been used for the treatment. The council of the tribe actually objected, and the again favorable result was obtained from the USPTO. Now, Colgate case. Colgate case is one of the examples how these large FMCG companies can actually attempt to use our ancient knowledge and market it as their patented technology or patented products and processes to get a patent. So what they did actually, that a couple of patents. So rust like red iron oxide was cited as one of the content. Clove oil, camphor, black pepper, spearmint are cited as the products, ingredients for the tooth powder and toothpaste. It was alleged that the products which were using for thousands of years for toothpaste are their own inventions. In a way, they have put up inventive step. All the patent ingredients were cited and the patent was sought. We opposed and we won the case. Now, with this summary, I mean to say, until now, you would have understood the need for the protection of the traditional knowledge. First is, definitely it is the legal recognition of the rights when we fight for it. Now, turmeric latte has known origins in India, haldi ka doodh, which we drink oftentimes. Also, it is the mean of survival for indigenous and tribal people. And in the process, we also conserve the biodiversity while we are following all these processes and while we are producing the elements which are used in all these things. So, if we don't get the economic consideration for our own knowledge, then what will happen? Naturally, all these people will be diverted to the present mainstream, what we call it. There will not be much of the incentive to invest the time and energy on the protection of the traditional knowledge. Most of the time, this traditional knowledge is preserved in their own languages. There are around 40 plus languages, as I remember, tribal languages, which we have only in the state of Maharashtra, which are still spoken. Otherwise, there are hundreds of languages which are being spoken by these tribal people when we're referring to the tribal people. If these people are moving into the mainstream, only for the survival, they will lose their language, and the knowledge has been transformed from one generation to other generation through the vocal means, not through the written channels, most of the cases. So if a language is lost because of it, the entire knowledge chain gets lost. It's a huge cultural change and huge loss for the country, for the community, and for the world as such. Because as we say, yoga is a global heritage. Similarly, the traditional knowledge in a way is a global heritage. It must be used globally for the benefits it offers, however, not at the cost of the indigenous people. Therefore, protection of the traditional knowledge is very essential thing. Now, since we are one of the oldest civilization on the planet, we are the powerhouse of the traditional knowledge. We started the movement for the protection of traditional knowledge. There's a history. I'm not going into the history and when the on what date, what event happened. You can just Google it and can get all the numbers. I will be highlighting the key elements. It is a traditional knowledge digital library. Why it is required? Because when we are talking about these patent applications being filed and being granted, patents being granted for the countries other than us, I mean to say in the US, in the Europe, or in, let's say, China, Japan, all over the world. What we need? We need a place wherein we can actually record, okay, this is what the traditional knowledge we have. Unless and until we assert, how would the world know? Because that is the classic defense, which would be put up. Okay, we're not aware, even if you have it. Hence, we thought, we are the first inventors. Because the way they say that discovery of India has happened only when the Europeans entered. So that's how the concept of discovery comes in, because they didn't know that such thing has existed before. And now digitally, these things are possible. Therefore, it is very important that we should have a digital library for our traditional knowledge. It has to be captured in the World Wide Web. It shall be given, it shall be accessible by all these IP offices across the world. And if at all they are granting a patent, then they should actually search in this database as well, like they search in the other historical databases while granting the patent. Therefore, if we talk about the language of big data, so it can be termed as the data lake of our age-old traditional knowledge, which is now made available for the IP seekers, IP right seekers across the globe, and we can actually protect our traditional knowledge. Now, how much data has been entered? So more than 2.6 lakh formulations from the text of traditional medicine systems of India, Ayurveda, Unani, Siddha are recorded. The library gives access to the non-patent literature database basis on traditional knowledge of India. So it's a very, very big thing which has been happening. Now, as I said, it covers the systems of medicines, Ayurveda, Unani, Siddha, Yoga, Ayush, in very short we call it. What it has basically the abstraction of the text and the formulation which we have in all these texts by the subject matter experts, because it should be done by the subject matter experts, because it's an area wherein not an ordinary person can come in and say something. Now, another important thing is that when we talk about the languages, when we talk about even our Ayurveda has been written in Sanskrit. So Sanskrit is not something, unfortunately, the popularity of Sanskrit has gone down. Even in India, we don't understand what has been written in Ayurveda, or in most of these cases, Siddha and Yoga for that matter. How would we think that it would be understandable by the people across the world? Therefore, it has to be in the languages which the world understands. Therefore, it has been translated in various other languages. I have it in the next slide. Therefore, what it does, it bridges the gap between the local languages, the knowledge which has been in the local languages, to the language which is understandable to the patent examiner at a global level. So it's a fusion of the traditional knowledge with the modern science. Now, as I said, we have the traditional knowledge in Sanskrit, Urdu, Arabic, Persian, and Tamil, Marathi, all the languages. We have, most of our languages have ancient origins, Pali for that matter. So all these languages. And it has been now made available in English, German, Spanish, French, and Japanese, 5 international languages. So if we cover these 5 languages, most of the things are covered. And now with the Google Translator coming in and helping us, even in a real time to translate the languages, so it won't be a issue. So when we consider the way ahead, all these technologies needs to be used in a very efficient manner for the systems to be more efficient. Now it has become mandatory for the patent examiners to refer the databases. Now, some of the success stories, or rather early success stories, I have put in here. The Unilever, has withdrawn their application for functional berry composition. This Gibson Biomedicine, a China-based company, they have withdrawn their application number, such and such, for medicament and food for treatment or prevention of obesity or diabetes, containing Cicer extract. Then Industrial Research Limited, Otago, it's a new New Zealand-based company. They have withdrawn their application for citrus fruit skin extraction. So, the orange peel or citrus-based fruit peel, which has been used for skin treatment, is known for us since ages. So there are so many such success stories which can even be Googled and can be seen. So this is all a success of the TKDL. And in order to celebrate this success, in 2009, a postal ticket was issued for 20 rupees. It has the spices on it. So we have, dhania, haldi, and mirch, some of the very important spices in our life. Though again, these spices have the medicinal values as well. So this is a ticket which represents that, and it also represents the major milestone of 2009. So now, though we have achieved success in this space, still there's a long way to go. So this is a 2015 publication. I have given the link of Deccan Herald from wherein I have sourced this data. So it is from V.K. Gupta. He is the former director of, he was the former director of the TKDL. They have identified 1,500 cases of biopiracy, of which 200 have been checked by the patent examiners, of which we won 180 cases. So look at the success percentage here. 180 out of 200 means 9 on 10, 90% cases were won out of the identification. It means our identification is very good, proper. That also means that at least at that point in time, 1,300 odd cases was still to be prosecuted. And this number keeps on increasing with the patent filing and the focus of the patent application filing at the global level. So when we talk about TK piracy, now until now we spoke about, or this is the general disclosure, even discourse that the biopiracy is something which has been spoken a lot. However, there are other forms of piracy as well. Varley painting, for that matter. We see Varley paintings done at various places. We even purchase Varley embossed t-shirts, Varley embossed cups, glasses, paintings, a lot of it. But do we even think that, what about the community? The tribes somewhere in Thane district or Palghar district, those who are responsible for this beautiful paintings, are they compensated? Whether an informed consent is taken from them for the utilization of their traditional knowledge of Varley paintings, Varley art, while we purchase this product? Whether we question the producer of these products who commercializes and who benefits from the marketing of these products, whether they have taken the informed consent, whether they are passing on any benefit, whatever minimal percentage it may be, to the indigenous communities out there, if they are making livelihood from those paintings? No. Similarly, in many movies or even in cartoons, we see the tribal life, tribal dances depicted. What about that? Do we have any protection in Copyright Act? Unfortunately, no. So there are other elements as well in the entire gamut of intellectual property rights, may it be trademark, may it be copyright, may it be GI, may it be designs. Even the entire landscape of the IP protection has an element of TK in it, and it needs to be protected. And what happens, with the misappropriation of the IPRs, erosion of the generic TK resources typically happens. And it results in the exploitation of the indigenous knowledge and biodiversity and the community at large because of it. Therefore, it's a very, very important aspect. Now, when we talk about the Patents Act, all the protections, if we talk about what are the protections. So Section 3 of the Patent Act is a very important piece wherein it has been defined that what is not patentable. So it is a definition which is being given in the NETI format. So what is not, right? So a long list of things which are given and that cannot be patented. For example, a computer code, can it be patented? The answer is no, it cannot be patented. Similarly, can TK be protected under patent? With the amendment in the Patent Act and insertion of Section 3P, an invention which is in effect is a traditional knowledge or which is an aggregation or duplication of known properties of traditionally known components are not patentable. Moreover, there is a provision that there is a need of mandatory disclosure whether any traditional knowledge has been used. So these are the provisions which are made in the Patent Acts. Again, these provisions in the Patent Act, there's a question whether they are sufficient or not. I'll be covering it in terms of the challenges, but this is a provision which has been done. Now, Biodiversity Act, which is another important piece of legislation. It has given protection for the biodiversity of the nation the biodiversity elements which I discussed in the earlier slide, that we are among the countries which has the 90% of the biodiversity of the planet. We are the major player. I have given all the numbers of the plant species and varieties which we are having. So there's a need to protect that, not only for the nation but also for the humanity, for the existence of the global humanity and life on the planet. Therefore, we have the Biodiversity Act, and it's a separate piece of legislation. Probably we need to have a similar session on Biodiversity Act, but I'll now only focus on the TK area in the Biodiversity Act. So in the Biodiversity Act, what they have done is they have formulated a committee which acts at the panchayat level. It is actually Biodiversity Management Committee. And that committee has been entrusted with several activities for the protection of the local plant varieties, for the protection of the ecology. At the same time, there is a provision for maintenance of people's biodiversity register. Now it happens at what level? At the level of the panchayat. So it's a classic example of decentralization of the governance. So panchayat raj system which we have, which is all about local governance. Because when we talk about all these things, and Haldi and Neem are basically widely popular varieties, or basically the plants which we know having medicinal qualities, but there are so many such plants available in the country. For example, even in Sahyadris, even in the Western Ghats, we have people from those are actually tribals, and they have certain they eat certain leaves, and those leaves are the energizers for them. And with that consumption of those leaves, they can walk throughout the day. They can undertake heavy physical activities. So it's a booster in a way. And that is something which is not known to that extent to the world at large, not even to us. So there are so many such medicinal varieties, medicinal plants available, and which are known only to the local people. Therefore, they are in the right position to record them. So that's why the provision in the Biodiversity Act for the biodiversity register has been made. However, again the question comes in for the implementation of it, because in our country, unfortunately, we have some very good pieces of legislation. However, the question comes on its implementation. Whether these registers are properly implemented, whether the data has been properly recorded, and then the question comes about the confidentiality of the data which has been entered in it. For example, somebody in a very good faith has done a very good job, fantastic job of recording all these medicinal plants and herbs, recording their medicinal qualities. And that register itself has been given to the person who wants to capitalize on it, who wants to monetize it by following all the ingredients of the biopiracy. What about that? It can very well happen. Therefore, the confidential information, confidentiality of the data plays a very, very big role. Therefore, what to disclose and what not to disclose, when not to disclose, and how these indigenous people would get their due is a big question. Therefore, the challenges for the production of the TK, traditional knowledge. First, it comes with the lack of awareness. As I mentioned earlier as well, we are not aware. And these people, for example, now that awareness has now, some sort of percolation is happening, and some people are now started realizing the value of the knowledge which they possess, which they hold. Therefore, at very minimal level, the documentation of the traditional knowledge has started. And the work which we mentioned about 2.6 lakh records which have been entered in the TKDL registry, which was done by the subject matter experts. But again, the subject matter experts, what they have done, they have read it mostly on the available manuscripts, available text, and the research which was carried out. The research is required to be carried out consistently. That is what is essential, and then, it is required to be recorded. And again, there are different types of conducting research. I'm talking before the audiences of the faculty. The audience here is the faculty members. Most of you are doctorate or have undertaken the postdoctoral studies. You know how the research methodology and research work happens. There can be in situ research. There can be, research which is based on the text which is available. But I'm talking here about in situ research, documenting the traditional knowledge right from the people, taking their interviews and recording it. It's a very hazardous task. And why we really need to consider it from the aspect of the property is also an essential element. Because most of the time when we talk about intellectual property, unfortunately, the due credit which has been given to the physical property or removable property is not given to the intellectual property. When we talk about a property, we immediately think about title, right? Many of us are based from big cities. Many of us are living in societies, living in flats. When we purchase a flat, what we see? We see the title registration, index 2 of the registered sale deed. Then what we see? What form of the society we are living in? Is it a cooperative society or is it an apartment under the Apartments Act? When we talk about the agricultural land, what we see? Whether the 7-well extracts are properly maintained or not. Whether the mutation entries are properly taken or not. Whether the cultivation entries are taken properly or not. What we do if we have a plot, we check whether we have the property card, PR card of the property or not. Whether we have fenced the property or not, whether it's an agricultural property or more so for the plots, so that somebody else can come in and encroach my property. The kind of care we take for the physical assets, physical properties. Do we really take that much of care for intellectual property rights? This entire discussion which we have had so far is all about title of the knowledge system. The way we consider it for a flat, the way we consider it for agricultural land, the way we consider it for a plot. Now we are considering about the title of the knowledge system. Who owns it? Who has the title? The way I say, okay, I have the title for my flat. The way I say I have title for my agricultural property, my plot. I should have the title for my knowledge system, isn't it? What's wrong in it? And that's why the property register is required to be maintained. The way we have PR cards, property registers in local panchayats, municipalities, similarly, this TKDL is nothing but the property rights register. It has to be properly maintained. Now the question comes in, even if we register it, whether we have the laws in place that recognizes the community rights. Our IPR jurisprudence, whether Indian jurisprudence or the global jurisprudence for that matter, is based on the individual rights system. And when we talk about the traditional knowledge system, it is not an individual's right. It is not an individual's heritage. It is the heritage of the society. It is the heritage of the community. Do we have a system that has given solution for distribution of the wealth, distribution of the property, distribution of the wealth which has been generated from the community rights, from the community-based traditional knowledges? Unfortunately, no. We don't have a proper framework. Whether the provision in 3P or disclosure in Patent Act would be sufficient, because it only says the patent cannot be registered. But what about monetization of the existing knowledge? What about that? The example which I gave about the Varli painting or the folk dance or the folk music which are used in our movies or in OTTs, wherever it may be, cartoons. Is there a system that a consent is required to be taken from this people, let's say Adivasi people, Koan people or whatever Vanvasi Samaj which we have? Do we have anything out there? No, there's no law. If there is an infringement of a trademark, if there is an infringement of a copyright, if there is an infringement of a patent or a design, I have a provision under the statute to seek an injunction. Section 63 of Copyright, 103 104 of Trademark Act. Similarly, provisions under Patent Acts, the clear provisions, statutory provisions. What a community would do if their rights are infringed? You would say, okay, I only explain the scenario, how we fought with Colgate, how we fought with, the Neem battle, Haldi battle, and stuff like that. Is it possible for every instance? Someone would say, okay, High Court can be approached under read jurisdiction. Is it possible for that ordinary tribal person to approach High Courts? Or can we put a burden for that on that person, okay, or that community which is already deprived, which doesn't have the resources to approach to the High Court or the Constitutional Courts? No, there's an imminent need to have a separate legislation to that effect. We don't have, and that is where even academia plays a big role as a pressure group. We, the practitioner, even the NGOs, plays a very vital role to build a pressure, to come up with policy papers, to come up with research papers on all these things, and have a system, have a mechanism that will enable protection of the traditional rights. Because otherwise there would be battle between the disclosure. Because when we talk about the IPRs, they are always about monopoly rights or exclusive rights. And there is a big emphasis on disclosure. And if our disclosure would result in stealing of our rights, both monetary as well as title, rights on title, then whether we disclose it or not is a big question. And therefore the confidentiality comes with it. Therefore, since community IPR rights is an essence of the traditional knowledge, and unfortunately it has not been captured in India. And if it has not been captured in India, it has not been captured elsewhere, because we are leading the battle for the traditional knowledge. Therefore, once again, I would say that the policy making from local level to the higher level, from local NGOs operating at the grassroots to the academia to the policy think tanks, there is a system which needs to be introduced by the legislators. Therefore, once again, these challenges which I have mentioned here, we don't have any protection in copyrights for the cultural knowledges. We don't have anything that protects the cultural expression of a community. Commercial art such as cinema, we don't have any equitable benefit sharing statute that mandates these people to share the rights, to share the profits with the community. And what happens because of this? There's no incentive for the community to keep on, to maintain their traditional knowledge. As I said earlier, since it is in the respective language, when a person dies and the language is not used, that knowledge also dies. Therefore, there is no incentive. Unless and until monetary incentives, unless and until non-monetary incentives are being given to these people, it is very difficult to sustain on that knowledge. So we need to incentivize the community to hold on their knowledge. The requirement of prior informed community consent is a very important aspect, because these days we're talking about our privacy rights, we're talking about our digital rights, wherein the suit which WhatsApp filed a month or two ago before Delhi High Court about the latest regulation on the IT Act, which are now mandated on this for the social platforms to implement. So WhatsApp immediately moved before Delhi High Court that how can we track, on the question of privacy, whether the consent of the party has been given or not, or for that matter, this Zoom meeting, when the recording button was hit, immediately a pop-up was shown. The recording of this meeting has started, whether you want to be on this meeting or not. Our informed consent was taken before recording. What about the consent of these people before utilizing their own traditional knowledge? So there has to be a provision in that aspect. Then cultural commoditization is something which is on the rise these days, which is a good thing in a way. We are commoditizing the culture. We are now having special boutique places, let's say restaurants, hotels, furniture shops, which are now representing the cultural expressions as a commodity. which is a good thing. That will incentivize these people. However, with that increase, we need the protection as well to happen. And that's where the statutory remedy and statutory provisions or a law is required there. And that is an essential element. And I'll also touch base very briefly on the requirement of the legal aid for these people. Since we have all the faculty members from different branches, so this is an interdisciplinary subject. It is not a subject which is limited to the legal department or a law college. When we talk about arts, expression of different arts, definitely different forms of the arts comes in, right from the filmmaking to, art, I mean to say, different forms of the art comes in. When we talk about medicinal benefits, immediately different branches of medicine comes in. When we talk about designs, when we talk about scientific and technological inventions, engineering faculties comes in, science faculties comes in. So it's an interdisciplinary approach. And this interdisciplinary approach has been, in a way, taken care by the law colleges or the legal department, because again, law is an horizontal branch. It is not a vertical branch. So law cut across the branches. Similarly, traditional knowledge cut across the branches. Therefore, we need an interdisciplinary approach, even for the legal aids, if at all we are really want to focus and concentrate on this aspect. We need to have labs, the way we have criminal law labs, the way we have civil law labs. Similarly, we need to have a lab, or a clinic, which can be owned by law department and can be contributed by other departments. So we need clinics dedicated for these things, and through those clinics, research can be done, and even the legal aid can be given. So this is the challenge which we are facing. Therefore, the road ahead, definitely we need a special protection enactment for the traditional knowledge protection, especially given the fact that now we have the global acceptance and recognition. Now we need to have a very clear legal policy, and we also need to have clarity on support, funding, and budgetary allocation for all these activities. We are talking about Atmanirbhar Bharat. There is a huge impetus around doing things in India. So Atmanirbhar Bharat is growing, Make in India is growing. So TK definitely can actually give an impetus around it, and definitely awareness. The more awareness, the better it is. And maximum registration of the data entries is also required. Hello?
Participants, kindly mute your mics, please.
Now, I'll stop with this image. I'm not sure whether you have seen this image. It is actually a promo actually of a movie of leading South Indian film star Surya. The movie is called Seven Sense. It is available on YouTube, and it is very relevant to the present topic which we are discussing, and also very relevant to the pandemic scenario which we are going through. It's all about a monk, a Buddhist monk. He actually designed the martial art technique and several other techniques. He's known as Zen master in China. But he's actually a Pallava prince from Tamil Nadu. He traveled from India to China. It's a real story. And he has taken the traditional knowledge from India to China. And now he is prayed in China like a god, And unfortunately, we don't know in India about him and his skills and his expertise. This movie is all about that. It has an outbreak of a pandemic, biological warfare, and so many different aspects have been covered in the movie. I don't subscribe to all those aspects. However, what I really want to emphasize by referring to this movie is that this movie has touched to the core of the issue of protection of traditional knowledge and what can go wrong if you don't protect it, and if you protect it, how can it be beneficial for us. So I strongly recommend this movie only for the concept which it brings in and how it is relevant. to the present subject. So it is available on YouTube. You can watch it. So with this, I will take a pause and I'll take some questions.
Oh, yes, sir. Indeed, there are questions that are flowing in. One question that I would want to ask, which has just come in, is with respect to registration of traditional knowledge. That would be based by the government, or would it be by the tribe that would be in the registration of traditional knowledge?
See, the registration can be done by the tribe itself. However, the requirement of proof is an essential element for that. So if we have the documentation available, then it can be registered and it can be put in the registry. The question involved here is primarily about the authenticity of the data.
Right, sir.
So we also have one question, which is the example of haldi uses as traditional knowledge? And can the process of application of turmeric paste also be protected by IP in some ways?
See, when we talk about the application of the turmeric, and if it is for all the known benefits, so when we apply turmeric, we all have seen the Vico turmeric wala ad, right?
Yes.
So so it gives a lot of benefits to your skin. It has healing capacities. So if all these known benefits or known qualities are sought for the protection, then it cannot be given.
Okay, so the next question is traditional knowledge an Indian initiative for only Indian or at global level?
It's a global initiative led by India.
Okay, so thank you.
And there are many such registries which are coming in other countries which are similarly placed like us. Those who have rich history, rich tradition, like Japan, the other countries which are coming in. There was a big fight initially with the typical Western mindset that the traditional rights are in the way of commercializing the products or the prospects. There was a huge battle. So it's a very, very a proud story to say that we have achieved so far, and there's still a lot to be done.
Sir, there's one more question. Can intangible concepts of one culture be also protected under IP to prevent misappropriation or exploitation? So, for example, Indian ideas around the concept of pranayam and some yogic practices have been misappropriated by a person called Wim Hof, who has trademarked a combination of pranayam and yoga as Wim Hof method, which he claims can give you protection against some extreme temperature variation. This is also traditional knowledge as per ancient Tibetan Buddhist practices. Any chances this could be challenged?
Yes, it should be challenged. It should be challenged. And that is what I referred when I referred on the slide related to the yoga. There are certain such practices were attempted to be registered under various forms of IP. Copyrights, trademarks, patents, utility patents, even designs. And the problem in terms of challenging it is the mentality which we have. Because all these rights are community-based rights. And the moment we say that these are community rights, and then we don't have a owner. Because the moment it is impacting me as an individual, right? For example, if I'm getting 3 marks or 4 marks or 5 marks less in my examination, and probably the teacher has either put a very strict lens, what we do? We immediately go to her or him and we ask and we negotiate with her to increase our marks. The way it happens with our marks, exactly the same thing happens with property. And when community owns it, what we need is the leadership, and leadership is a very rare thing, to be seen in these communities. And that is where people like us are required to come out. The way in that clip as well, the lawyer, who was practicing in some city, when she realized, okay, something of this sort is happening, then we need to come forward, we need to highlight, and we need to bring it to the attention and get it stuck off wherever it is. And get the important aspect is, since we are lawyers and you are a law student, so law is all about collecting the data and collecting the evidences. So oftentimes collecting evidence is also a challenge, and that's why registering in TK as well. We need to have authentic sources. We need to have proper capturing of the tradition, the interviews, the recordings, and in fact, WIPO has published a document on how to conduct the research. And the research activity which has been undertaken, can that be protected under IP is also a question. So if you're recording a tradition, the format in which you are recording, the tables, the data structure which you're creating, can that be copyrighted? So there's a gamut of questions out here. However, to answer the question in short, yes, it can be opposed and it should be opposed.
Thank you, sir.
So I have two follow-up questions coming up on this. So what they're asking is, so like you just said about the method of research itself that can be copyrighted or protected. So for example, we have many oral traditions, which is very difficult to, say how long or how ancient they are. So the first question is, can that be protected in some way or claimed as a source of that knowledge or used as an evidence? And the second question is, going back to the previous question about this Wim Hof method, is there any limitation on how long does a person or a community have after their knowledge has been trademarked by somebody after misappropriation?
Very, very good questions. So to the first question, when we talk about the oral traditions, so even our Hindu law, for that matter, is based on Shrutis and Smritis. So it is also, when we talk about Shruti is a written text, and when we talk about Smriti, is an oral tradition. So we have even concept in Hindu law that the traditions in a particular region, especially in the personal law paradigm, that those traditional traditions, or even if they may be oral, they can be acted as a source of law, right? So if a tradition can act as a source of law, similarly, utilizing those I want to say spices or those plant varieties or whatever that traditional knowledge is comprised of, whatever the source may be, if it is passed from generation to generation through oral tradition, it has been used in a certain way by that community. And if we can take the undertaking or the affidavits or the interviews of that community, that shall be sufficient for that particular use. And we can actually rely on it because there is no documentation available prior to that. And those people from whom we are collecting the data or the evidences, they are in a way not connected to the educated world, I mean to say, so-called educated world. Therefore, it can be very well treated as the source and can be fought upon, the battle can be fought upon that basis. Now, your second question, if I recollect it properly, is about the limitation in a way. So, what shall be the time frame with which the opposition can be made up? So, even if we consider general statute of limitation, so general statute of limitation also has two major elements. One is the clear knowledge, which is very important. Even if a decree has been passed, but it has not been brought to my knowledge, and I can prove that, okay, it has been brought to my knowledge only after a certain date, then my limitation period starts from that point. So far as these things are concerned, wherein things are happening at an international level, it is very unlikely that the tribal community can get that knowledge very efficiently or on the very next day, or we don't have any watchdog as such. Ideally, yes, the TKDL, that level itself, there are certain things which are happening wherein they are continuously monitoring the patent applications which are filed, and a proactive measure has been used to object several such applications. Whether that is truly efficient, that's a separate question. However, that proactive monitoring is happening. However, that proactive monitoring is happening at the India level. But when we talk about a specific case which involves a specific tribe, let's say, from Western Ghats, or let's say from Eastern, Northeast India, then for that community to know that, it may take very long time. Or this Tibetan example, which was just sought after, to get that information in Tibet, and the person residing in Tibet, that too in current scenario, under whatever political scenario with China is going on, it's very difficult for those people to come out and oppose it. Therefore, this statute of limitation and my knowledge of that thing plays a big role. It has to be filed bona fide, and our bona fide is required to be proven while opposing. And once our bona fide and good faith has been proved, I don't think there would be any issue so far as the limitation is concerned.
Thank you, sir.
Sir, even in fact, there are so many methods and so many, like as what you discussed with respect to the martial arts and things like that. That way, India is also rich with, for example, Malkham.
Yes.
So that could also be an initiative which should be taken for protection under traditional knowledge, I guess.
Exactly, madam, and that is where I mentioned the need of having a special statute for that.
Yes.
We don't have a law for that. For example, if you want to protect it, what we can do right now, we can put it in the registry. But after putting in the registry, do I get any preferred benefit? And the answer is no. Can I file for injunction? Answer is no. Can I file a? Can I sign a licensing agreement? Answer is no.
No.
So there is no mechanism available.
Mechanism.
Yes. So in the meantime, what can be done is, again, it's a workaround kind of a thing. All these things can be protected by the respective communities. I mean to say, for example, you mentioned Malakham, or we have similar Kalaipatam, in Kerala. These are different forms of martial art for that matter. So we have associations of these people coming in. Again, there's a different fact that this association fight among themselves. However, if there is a nodal association which represent these people, then that association can actually file for copyrights, can actually file for design, because these all forms are, mostly get into copyright protection, because these are the techniques which they're using, and trademark, Malakham for that matter. And that association then can do licensing, so that can be a workaround in the meantime. However, law is the essence, actually.
Yes, very true, sir. Very true. In fact, it's an area which is still unexplored, I would say.
Exactly.
Traditional knowledge, and it requires a lot of legislations, as what you're putting up with the provisions under traditional knowledge. Yes,
exactly.
Definitely. And definitely, it is an eye opener for all of us. This, especially in the academic field, where it's an interdisciplinary subject.
Exactly. Even within IPR, it is interdisciplinary, because it not only attracts patent, but all the other forms of IPR, and even beyond IPR, as I said, all the forms of knowledge, I mean to say, the education faculties which we talk about, it attracts to that, and it goes even fundamental to the very basis and notions of law, community right as well as the individual property rights. So, I would strongly suggest, if a cleric can be done on it. And
yes,
especially
definitely.
when we bring digital into it, I mean to say, because with digital, the movement of data and movement of thing has become very, very fast. So, all these things come, club together. There can be a subject of clinic. So, yeah.
Yes, definitely, sir. Yes. Any more questions? Any of the participants who would also want to ask, they can also unmute their mics. Right. So, Rohit, will you go ahead with proposing the vote of thanks?
Ma'am, Aditi will be continuing with that.
Yes, ma'am. So, thank you, sir, for an enlightening presentation on traditional knowledge and confidential information. We appreciate having this wonderful area clarified. As we know that traditional knowledge is one of the great importance in current international system for protecting intellectual property. Innovation based on traditional knowledge may benefit from patent as a trade secret or confidential information. Some topics like particular tradition, community rights, tribal people, and a digital library are of great use, and the success stories definitely motivates us. We appreciate your presence here, sir. We look forward to have some more sessions with you in the future. Thank you, sir.
Thank you very much, Rajlakshmi ma'am, and the entire team for inviting me and giving me this opportunity to share my thoughts with you. Thank you very much.
Yes, sir. Indeed, a very wonderful session, sir. We could also we are do thinking about having clinics and things like that. Those wonderful suggestions suggested by you, and thank you so much for sparing your valuable time, sir. Thank you.
Thank you.
Thank you, sir.
We shall have our next session starting sharp at 12. And our next resource person would be Advocate Anand Mohurkar, sir, who would be speaking on patent life cycles and management. So till then, we shall take a small break and we'll rejoin at 12. Manoj sir, are you there? Muhurkar sir, good morning. Advocate Anand Muhurkar sir, good morning. Can you hear me?
Yes, I can hear you. I
Yes.
thought it was for some other person. Good morning.
No. Good
How are you,
morning,
ma'am?
sir. Fine, sir. How are you, sir? Seem
Excellent.
tied up with your hearings in the court?
No, thankfully today it was not there.
All right. Okay.
That's why I took a
Yes.
later form. By any chance, if I have a hearing, I can get adjournment.
Yes, sir. Definitely. So you have your PPT on? You can share it?
Yeah, I'll share after some time. You can
Yes.
kick off the program.
We'll start with the program, sir. All right. So shall we begin?
Oh, yeah. Oh, I did
Yes,
not
sir.
know that my cam is off. Okay.
Right. Good morning to everyone. This is our second session of Day 2 FTP program on intellectual property rights conducted by New Law College under the cell of AETIP and CL. We have Advocate Anand Muhurkar sir, who is going to speak on patent life cycles and management. So I welcome you, sir. I request Aditi Srivastava to go ahead with the introduction.
Yes, ma'am. It's a great pleasure for me to introduce Advocate Anand Mukher, sir. Sir is a member of Bar Council of Maharashtra and Goa and has completed Masters in Manufacturing System. Sir is a registered patent agent of the Patent Office of India. He is the founder of law firms AM Legal Associates, NAM Legal Associates, and ANV Legal Associates, which is based in Pune. He holds a PG diploma course in cyber law, cyber forensic, cyber security from IFS Pune. Sir has 17 years of experience in legal industries, academics, and manufacturing. And Sir has expertise in intellectual property laws, commercial laws, corporate laws, consumer protection laws, cyber laws, IT laws, and many more. He is a legal consultant of number of SMEs. He is also involved in legal counseling of joint ventures, commercial contracts, brand protection, startup strategies, innovation management, consumer protection, and IP portfolio management for some of Fortune 500 companies. His goal is to generate IP worth 2,000 crore for protection. He is impaneled on the advisory boards of several companies universities, and academic institutions as a legal advisor. He is also visiting faculty in many deemed university like BITS Milani and also BPP, and has conducted 100 various awareness programs on IPR laws, consumer laws, and labor laws. Sir is going to talk to us about patent life cycle management. First of all, thank you, sir, and I request you to please start your session.
Mahurkar sir, are you there?
Hello.
Yes, sir.
Ma'am, we can, before I proceed, can I
Yes.
get to know about the profile of the people we have as participants today and what was covered yesterday, so that I can catch up with them and
Yes,
try
sir.
to explain in very simple words.
Right, sir. Yesterday we had, in fact, as you had mentioned, we have, this is a faculty development program which has been organized for the entire Bharati Vidyapeeth, staff of Bharati Vidyapeeth. So all of them are from different disciplines. They are from medicine, they are from engineering, they are from pharmacy, they are from the other colleges of ours, architecture and nursing. We also have them. So this we have these faculties, since IPR is a interdisciplinary subject. So that's why we have taken this up for awareness and bring about IPR awareness amongst all of us. So this is one aspect. Secondly, sir, as you had said, yesterday we had speakers as per the schedule that is laid down. So we had speakers on geographical indications. We had that was Anand Ganesh Hingmire, sir. Then we had a speaker, Advocate Tanu Singh, who spoke on patent novelty, patent cooperation treaty. She spoke more about pharmaceutical patenting and the procedures for filing of patents. And previously, before you, just now, we've had a guest session on traditional knowledge and confidential information given by Advocate Ashish Soname, sir. Yes, sir.
Okay.
This
and
is how the
profile
yes.
of our audience, I mean, or the background, etc.
Profile of our audience is they are from different, they are doctorates, pursuing doctorate, professor, assistant professor, and till the grade of professor. Most of them are doctorates. Some are pursuing their PhDs. So, and they are from different disciplines of Bharati Vidyapeeth, sir.
Okay. Okay,
Yes.
great. So there is no student here, right?
Students, we have two of the students who will be assisting me.
Okay, so
and yes.
speak about IP, that's why they are. Okay, okay, great.
Yes.
So, because the kind of level of professor is very high, and many of them must have already filed some patents or granted patents with them. So we can, go to a higher level when we discuss things.
Yes, sir.
Okay, great. So good morning, everybody. This practicing IP lawyer, and we have a law firm in Pune. I think I might have met some of you in the past also. So the topic for the day is patent life cycle, and we are going to cover the patent life cycle. And there is one more word, that is patent life cycle management. So there are various aspects of the patent life cycle management, but today I want to make it as a very participative program, because I am seeing these days that you deliver a lecture and a talk and nobody's bothered. So that should not happen. So from the beginning, I'm going to request you to participate in the chat.
Sir,
are we all?
One thing, since we have been connected to the YouTube, sir, so we don't have the chat box here.
Please connect me from YouTube, because I do not want to go on YouTube. I had already told that.
Yes, sir. I will just make that to our technician. Manoj sir, are you there, Manoj sir?
बोला ना मॅडम.
हा, मनोज सर, युट्यूबचा हे ना डिस्कनेक्ट हवंय.
सर, आपल्याला YouTube लाईव्ह नाही करायचंय, कारण की काही एक्झाम्पल्स गोष्टी